We're live. So welcome to everybody and to everybody online. Kelsey just passed out copies of Wage Order 4 just to have a sample. So if you haven't seen them before, you'll see what I'm referencing. I was probably an employment lawyer for a couple years before I actually looked at the wage orders or could really explain what they are. And we've never done something just specifically on the wage orders. The one thing that we can't do today is go through with everybody specifically which wage order or orders apply, but we can help you with that offline if that becomes an issue. And we don't have our big screen today. Apparently our projector is at the doctor. So if you can't see that, it is in the slides. Does everyone have slides? Yes. Just kind of want to give an overview of where the wage orders fit into the whole scheme of employment law, specifically of wage and hour law. Legislature passes laws. There's a bill, they pass a law. They then give it to and it's really just a skeleton. They give it to the Department of Industrial Relations, and under the DIR was the Industrial Wage Commission, which apparently is not there anymore, but it's still, the wage orders didn't go away. They give it to the Industrial Wage Commission that really fills in the blanks. They create the regulations, and those regulations go through what's called the Administrative Procedures Act. There's a public comment. Sometimes you'll get an email that says, if you have any comments on this, please let us know in the next 90 days or something. At the end of that process, those wage orders have the power of law. It's the same as the labor code because they've been through that process. So labor code, law, wage orders, law. They then have an enforcement arm, which is the DLSE, Department of Labor Standards Enforcement, the Labor Commissioner. The Labor Commissioner enforces the wage orders and the labor code. They also have opinion letters. They have, if anyone's ever looked, they have their playbook, which is the DLSE enforcement manual, and it has a lot of things in there about how they enforce the wage orders or the labor code. A lot of times you'll call and you'll ask me a question and I'll say, well, that's kind of undecided. Labor Commissioner enforces it this way. Here's what the wage order says. And what that means is that the labor code and the wage orders don't get to the level that we need to for the question that you're asking. So we look to the DLSE enforcement policy, the Labor Commissioner enforcement policy, just to see how they interpret it. That's when I'll tell you sometimes I'll say Labor Commissioner's wrong. Well, how are they wrong? They've picked an enforcement policy that I don't think is legitimate. I don't think it has a case behind it. I don't think it's supported by the law. So that's a situation where we'll tell you, Labor Commissioner might rule against you on this. I think if we get to court, we're going to win. So that's why sometimes we're a little wishy-washy. It means you're asking a very good question that has not either been litigated yet or just isn't included in the statutes or the wage orders, okay? If it's in the labor code, we'll tell you. That's the law and this is what it is. As you know, in California, you've got the Federal Fair Labor Standards Act, and then you've got the state law. And I'm just talking about wage and hour right now, how we pay employees. You have to comply with the Fair Labor Standards Act in most circumstances. You have to comply with the labor code, and you have to comply with the wage orders. And labor code, like I said, is sort of big picture. Wage orders fill in the blanks, and there's a lot of not only differences, and they're hard to spot between the wage orders. There are differences between the individual wage orders. There is also some contradictory and some overlap between the wage orders and the labor code. And you would think when people were passing the regulations that they would at least be consistent with the labor code that they're filling in the blanks on, but for some reason they don't. The biggest differences between the labor code and the wage order, labor code is generally broader. On some things it's specific. I like to say it's the bones. The wage orders are the meat on the topics that it covers. The wage orders are limited to wages, hours worked, record keeping, that type of thing. They don't address a lot of the other things that are in the labor code. So for what the wage orders do, they're generally going to be more specific than the labor code. Wage orders and labor code can both be enforced at the labor commissioner, a claim. They can be enforced in court. Both are applicable to most businesses. And then the overlap is generally as it relates to hours, working conditions, record keeping. There's going to be some overlap. For example, the labor code says you must provide a pay stub with this, 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 and this in it. The wage orders also have information on what you have to put on a pay stub. So you have to comply with both of those. Here's a list of the general topics that are covered in the wage orders. Most of them they go in the same order too. If I tell you Section 3 or Section 4 of Wage Order 4, it's generally going to be the same in Wage Order 14. They're at least organized similarly. They were not all passed at the same time. They've had different revisions. That's why they don't exactly match. And I'll point out some of the important inconsistencies. The first section in all of the wage orders, and you have that section, Wage Order 4, the first section is always the exemptions. And it tells you, who is exempt from the provisions of the wage order. And it goes through the analysis of the exempt, executive, the administrative, the professional. Okay, so when I get a call and they say, well, they're on salary, and I say, no, are they exempt or non-exempt? What I mean is, under the provisions of your particular wage order, does this person meet those exemptions? And that's where the term comes from, exempt from the wage orders. It addresses overtime, the wage orders, and that's critical because there are differences. The ag ones have different overtime provisions, different work weeks. The transportation, number 9, industry has different overtime provisions. Alternative work weeks. This is one where the wage orders are different. Some of them, and I think it's because they were revised at different times, some of the wage orders have a little bit different alternative work week provision. And this is where you'll see the vote. When you say, how do we do an alternative work week? It's in Section 3, I think, of the wage orders, and it tells you exactly what you have to do. That's where that comes from. And then little things like people working outside of their schedule, things like that. Those are addressed a little bit differently per wage order. So we want to look at that. It addresses minimum wages, reporting time pay. When you say, someone shows up and we send them home, and is it 2 hours or 4 hours? That's going to be in your particular wage order. Records retention, how long you have to hold on to records. Cash shortages and breakage. When you call about tools and uniforms where someone broke something, can we charge them? That's in the wage orders, and it's also in the labor code, and this is one of the big inconsistencies. That's why we have trouble answering that question. Labor code has this provision for deposits and lays everything out in a certain way. Wage orders, depending on the wage order, have a little bit different one. It talks about you can take it out of their check if they authorize it. You ask the labor commissioner, because we've got an inconsistency, they say in their enforcement manual, we don't really agree with the wage order, but since it's law and the labor code is too, we're kind of bound to kind of do it, but okay, we'll approve it, but read between the lines. If we find any reason why we can ding you for deducting from their pay, we're going to. Okay, that's a situation where there's a lot of tension in the uniforms and the deductions. Meals and lodging. This goes to sometimes live-in people, or when you send people out on travel. Meal and rest periods are addressed in the wage orders. And the required posting of the order. I'll give you an example. All of them say you have to post them. Then you've got Wage Order 16, on-site drilling and construction. People go from their house straight to the job site. Where do you post it? Well, if you look into Wage Order 16, it's one of them that has a little exception that says, If there's nowhere to put it, you can put it in a binder, but the binder has to be in the truck, and everyone has to know where the binder is, and they have to be able to get it. It can't. So there's real specifics depending on the wage order. The reason I point out that one is that if you get a labor claim, labor commissioner says, well, do you have your posters? And you say, no, we don't have our posters. People go all over the place. Well, there's a provision in there. If you have it in a binder and it's in the truck and you follow it, you're good. If not, they're going to ding you for it. Okay? Any questions so far? Okay. Basic first step. You need to determine which wage order or orders apply. And there are different wage orders, different types of wage orders, and here's how they interact. There are 3 occupational orders, there are 13 industry orders, and then there's a miscellaneous order, and then there's this hybrid one, number 16. And it will determine primarily what you're going to be concerned about is overtime is a biggie, and what are the exceptions from overtime. For example, wage order 9, transportation industry. If you are a trucking company and that's your industry, it doesn't have daily overtime. It's weekly overtime. It's 40-hour overtime. So if you had somebody working in the office but you were in the transportation industry, then you can pay them differently than you do virtually every other employee in California. Now flip over to a different wage order, 10, 15. It says, okay, everyone gets daily overtime, but then there's a little exemption for drivers, for DOT drivers or drivers regulated by the California Highway Patrol. Okay, so that pulls them out. It's like it's the mirror image of the transportation. Then you go to wage order 16, it has daily overtime. It doesn't have the exemption for drivers. So it gets very confusing when you've got a trucking company, but the trucks go onto a lease. They get out of what they're doing, now they're on an occupation order, and I'm going to explain that a little bit better. The first thing you look to is industry. That's primary. Do you have an industry order that covers all of your employees? And that's a very specific analysis. I've used the example transportation. A trucking company that has long haul and that's all they do is transportation industry. What about a manufacturer that has a fleet of trucks that delivers their own stuff to distributors? A lot of trucks. You could have 100 trucks. Are you transportation or are you not? I'd say you're probably not. You're probably manufacturing. But strategically, what you might say is, you know what, we might want to carve off that section, the transportation group, to get under a different wage order, to make sure there's no ambiguity about daily overtime. So you start with an industry. If there's no industry order, then you look to occupational orders. There are 3 of them. The most common is number 4. A bank is not an industry, okay? An HR services company, a law firm, there's no industry order. Those fall under this miscellaneous occupational order. So that's not industry coverage, it's employee by employee, which means under the occupational orders, you can have different employees covered by different orders, okay? So if you are a construction company, there is no construction industry order. It's an occupational order. The ones that work on site get paid in a particular way and are under 16. Your employees that work in the office are under wage order 4. And there's a lot of similarities, but there are some differences. So step 1 is there an industry? If not, if we're under the occupational orders, which ones, how many apply? For a bank, a law firm, an HR company, it's easy. Everybody's under 4. For a manufacturer with some drilling company, a trucking company that goes on leases, you've got some different issues. The first one is manufacturing. The second is personal services industry. Haircutting, janitorial, I believe. Freezing and preserving industry, I have not run across that one yet. Public housekeeping, that's a big one. That's hospitals. It's some of you who have facilities or programs for developmentally disabled or elderly. But then there's 15, and I might have gotten these backwards, that covers in-home care. Five covers in-home. Okay. Anyway, there's 2 of them. And it depends on this is what's amazing to me. I have 2 clients that do basically the same thing. Take care of people in their home or take care of it in the consumer's home. One's under one wage order, one's under a different one. It's where the care is given. Laundry, linen supply, dry cleaning. Mercantile is pretty much the retail one for people that it's very specific on product sales. The transportation's a big one. Amusement, recreation, broadcasting, motion picture, and then industries preparing products for market. That's industries. That's an industry ag order. Okay. Now, when you look at the occupational orders, 14 is an occupational order. So if you're not under an ag industry, but you have ag employees, you got to look at wage order 14 for those employees. Household occupations, miscellaneous employees. I've never figured out how that interacts with 4. They generally fall under 4. And then 16, which I call a hybrid. And the reason 16 is so different, I said earlier that if there's an industry order, it covers everybody, regardless of what they do, and then you go to the occupational. The only one that's different is wage order 16, and it's how it's worded. Even if you have an industry order, 16 trumps it for the employees that work on site, drilling, logging, construction. Okay? So that's an exception to the general rule. That's one where 16 trumps an industry order. And really, it's just looking at what do people do, what do we as a company do primarily, and then from there you get your wage order and you work through it. Any questions on that? Okay. Going back to the multiple wage orders, if you have multiple wage orders, you have to post all of them in the appropriate place. So a construction company might have 1 in the binders, 16 in all the binders in the trucks and on site, and then in your office you might have 4 and 16 and whatever else applies. In working through them, let's assume you figure out which wage order you're under. I just kind of want to walk through the wage order and what you're going to see. The first section tells you to what industry it applies, but it doesn't really define it. It just tells you. You then have the exemptions, and that's what we talked about, executive, administrative, professional. It's not all the exemptions. Computer professional, some of the other ones that we see, it's only the ones that the wage orders address. Those are the only exceptions to the wage orders. Okay, so you might have an employee that there's no exemption under the wage orders, but they're exempt under the labor code. So you have to kind of look at both of those. So then you get the exemptions and it tells you how to do it. And then I believe section 2 is definitions. If someone can, is that correct? Big heading 2, I think, is definitions. It's one that we tend to gloss over. That's a critical section because the definitions of things, of the same things, are different in the different wage orders. Every term of relevance that is used within the body of a wage order is defined in the beginning. The one I go back to is the personal attendant. Okay, in one of the wage orders, it says you've got to do this, 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 and then it says doesn't apply to personal attendants, and then blah, 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 blah. And you say, well, wait a minute, what's a personal attendant? It's defined in the beginning, so you have to go look at that. The other area related to those definitions that you have to be careful with is in that one that says, okay, personal dependent or personal attendant is exempt. you have to look at what it's exempt from. Some of the exemptions say from this order, some say from this section, okay? And section means either the numbered section or the lettered section. It's different in the different wage orders. So you look, you see a word, you go to the definition, you say, that exemption meets, we're good with that one, we meet that definition. Then you have to figure out what they're exempt from. Okay, so pay very close attention to the definitions. The third section is going to be, I believe, the wages, the daily overtime, hours and days of work, okay? This is where you've got to define your work week. You know, is it Sunday to Saturday? Is your work day midnight to midnight? It also will tell you basically what you have to pay. You know, these workers get time and a half, double time. It addresses seventh day premiums. All of that is in that section, and those are different. Like I said, some of the ag ones are different than your standard wage orders. Then you have the alternative work week stuff that comes, I believe, right after that. And I guess I could just look at one, but I've seen them so many times. You've got the whole section on alternative work week. It's 2 or 3 pages. If you have an alternative work week in place and you identify your wage order, go through that section and look for the exceptions. People working outside of their schedule, make-up time. Most of the wage orders, for example, have in the alternative work week section, if at an employee's request, they can work outside of the schedule in the same work week, and that time outside the schedule isn't necessarily overtime, which is the general rule at the employee's request. One of the wage orders doesn't have that provision. So employee says, hey, I know I work Monday, but can I just do Tuesday through Friday? Sure, yeah, same thing, 40 hours, 4 10s, just a different day. In most of the wage orders, that's okay. In one of the wage orders, I don't recall which one off the top of my head, that's not okay. The 10 hours on Friday are outside of their normal schedule. They're all at time and a half. So if you're the unlucky wage order on that one, then you can't do that, or you can, it's just more expensive. It talks about even the detail of how to break down an hourly. There's lots of little things in there, like how to get an hourly rate for an employee who's paid by salary. It tells you how many number of hours, 40 hours constitutes it. Some of them say 2,080. So when determining what someone gets paid per hour, sometimes it's in the wage order. And these are things we don't think of. You might go to the labor code and you look through there and you say, God, it doesn't tell me how to figure that out. Probably doesn't. If anywhere, it's going to be in the wage orders. I hate to do this to you, but raise your hand if you've really ever read your wage order. Okay, about half. That's probably higher than if I'd asked that 10 years ago. I would have gotten maybe one, and it would have been the Cal State student that was just sitting in auditing the class. Okay. Then the key for you then, once you figure out the wage order and what it says you need to do, you really want to comb through there and see what exceptions or exemptions are going to apply. Okay? Oftentimes, that'll appear in 2 places. In the body of it, it'll say, doesn't apply to commissioned salesperson or outside salespeople, blah, 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 blah. An outside salesperson, it won't be capitalized. Capital O, capital S. It won't be that. It'll just say outside salesperson. And you think, oh, they're outside. They're selling. Okay, no big deal. Go to the definitions and look, because outside salesperson is specifically defined for that particular exemption. The other little tricky thing, and these are all just little tricky things, that's why I wanted to do this, it's just to kind of give you an idea. Sometimes they've copied the definition from exemption or from wage order to wage order. Like outside salesperson might be defined in 3 or 4 wage orders, but it doesn't appear in the body. Okay? So just because it's in the definitions, outside salesperson, and you know that's defined as XYZ, and in wage order 4, they're exempt from overtime. Just because you see that definition in wage order 8, the exemption does not apply unless it's in the body of that wage order, okay? It has to specifically state that outside sales people are exempt. And I think they just cut and pasted some of the definitions, so they have definitions in wage orders where they don't apply. Okay, this is our government at work. The child labor provisions, most specifically hours worked, when minors can work, how many hours in a week during the summer or school year. The 1 day's rest in 7. This is a strange one. It's both in the wage orders and in the labor code, and it isn't exactly what it means. If you go read it and you say, oh my gosh, every 7 days someone has to have a day off. We haven't been doing that for 100 years. We're in trouble. It means the equivalent of 1 day off in 7. So 4 per month. Yes, you can work someone 12, 15, 16 days in a row. Over the course of 1 month period, they have to have the equivalent of 1 day off for every 7 worked. And it doesn't say that in either the wage orders or the labor code. Talks about collective bargaining agreements. Some of you that have union contracts, scattered throughout all the wage orders, here and there you'll see the provisions of this section don't apply if you have a collective bargaining agreement, or if you have a collective bargaining agreement that provides at least a premium for overtime hours. You know, they're a little bit different. So if you have a collective bargaining agreement, you want to go through there and look and see how does that interact. Graveyard shift, meal facilities, providing food. If you have 24-hour-a-day operations, there's some funny little provisions in the different wage orders. Wage order 16 is the only one that states for employees out in the field, you have to have hand washing facilities. Well, it seems to me if we create a wage order for people out in the middle of nowhere, that we're not going to have a hand washing facility out there. So you have to work around that. Is it hand cleaner? Is it water on the trucks? But that's in wage order 16. Talks about having a place to have a hot meal for certain overnight occupations. That's either a microwave, a hot plate. That's a very specific one. The DOT exemption's huge. That would be at the end, I believe, of section 3. There's a paragraph, and it says, the provisions of this section, which would be just the daily overtime, do not apply to employees, not industries, to employees who are, and there's 2 subsections, A, subject to the service hours under CFR such and such, Department of Transportation. The other one says under the Code of, or the California Code of Regulations. It's basically known as the CHP exemption. The federal exemption is a little broader. The state exemption and the CHP exemption is based on size of the truck. So it's tiered. You got a big giant truck, you're exempt. If you have over 10,000 pounds, you're kind of exempt. If it's under 10,000, you're not. So you might fall under the federal, but in the state you want to look at it and analyze whether or not. Why would you do that? Because if you've got a lot of people driving big trucks, driving around, but you are not in the transportation industry wage order, you got to pay them daily overtime, unless you can use one of those exemptions under the exception under Section 3, okay, for DOT or the CHP exemption. It's a great exemption if you have a lot of drivers, if it works. 72-hour weekly maximum. I can't remember what that is. I think it's, I can't remember. I'm sorry. It also talks about the makeup time provisions here. The one that we put in the handbooks where it's an exception to the overtime, the daily overtime. So when you say, you know, we've got this employee who works 8 hours a day and they say, you know what, on Wednesday I've got to take child to a doctor's appointment. Can I work 6 hours on Wednesday? I'll make it up on Thursday. And normally you'd say, no, that's 10 hours. We'd have to pay overtime. Well, if you go to the daily overtime section, some of the wage orders have an exception for that, an exemption, and it's the makeup time provision, and it tells you exactly how to do it. And that we see that as a policy in handbooks, and we even put it in, but really what it is, it's an exception to the wage order daily overtime provision. Okay? Any questions on that? Make sense? Doesn't sound like a different language? Okay. Minimum wages are addressed in there, and minimum wages, the only time this really comes up, gets a little tricky, is when it turns out somebody is working off the clock, or working, you have an hourly non-exempt employee working at home. If it's a lower paid employee and those hours get deemed to have been hours worked, it dilutes the hourly rate. You can run into a minimum wage problem. We never worried too much about that in the past because it didn't happen that often and there really wasn't a penalty. Well, there was, it wasn't enforced. Starting January 1st of this last year, the Labor Commissioner now enforces this penalty from the wage orders, and it's a liquidated damage penalty. And basically what it is it doubles whatever the underpayment was. So if it turns out that you underpaid someone under minimum wage for 200 hours, you owe them that 200 hours, plus they're going to double it as liquidated damages. And any of you who've gotten Labor Commissioner claims this year, after January 1st, that's a new line item in the long line item of penalties. And that comes from the wage orders. The split shift premium. This is one that everyone sees, everyone calls about, and it hardly applies to anybody. The general provision is this. They don't want you calling in low-paid employees, calling them into work, sending them home, making them come back sometime later in the same workday. They say if you do that and it doesn't meet the exceptions, like a meal period, you have to make sure they're compensated for that. And here's how it works. An employee on a split shift premium, an hourly employee, and this is not in, none of this is in the wage orders, just the split shift premium is. An employee has to earn the equivalent of minimum wage, $8 an hour, for every hour during the day that they worked, plus one additional hour. Okay? So if someone did a split shift, 3 hours and 3 hours, okay, and you paid them 6 times 8, $48, okay, you have to add $8 to that. Minimum wage for all hours worked plus 1 hour at minimum wage. So they'd have to make $56. If you paid that same person $9 an hour, so they made the equivalent of 6 hours at 9, $54 an hour, you only have to pay them $2. Because you look at all hours worked, 6 times minimum wage is 48. You paid them 54. The threshold was 56. You got to pay them $2. You got someone at $10 an hour, you work them a split shift premium, there's no premium because you take those 6 hours times 10, it's $60. It's more than 6 plus 1 times $8 an hour. It's more than $56. So the split shift applies to everybody. The premium only applies if they're under that $8 extra pay. Does that make sense? And yeah, like I said, you won't find that. It is in the the DLSC enforcement manual, kind of. It's not very clear, but that's the way it's enforced. It's just a math equation. Hours worked plus 1 hour at minimum wage. Divide that by total hours, or total pay. If you paid them more, you're off the hook. If you paid them under, you gross them up. Okay? Licenses for disabled workers. There are some provisions to encourage people to hire disabled adults. There's some provisions in there that you can get a sub-minimum wage rate. And it isn't utilized that much. It doesn't apply if that's your industry, but to encourage normal businesses to reach out to that community, there are some provisions that you can pay less. And you won't find that anywhere else than in the wage orders. The record keeping requirements, talked about that. The cash shortages and breakages. So when you call me and say, this person's come up 10 times short on their cash drawer, we're going to deduct it from their pay, I would say, look at the wage order, because it doesn't allow that in there. There's provisions for that. So if you're in retail, you want to know that. Uniforms and equipment. Wage orders cover both who has to provide uniforms, and this has come up a lot with the new fire retardant clothing. It talks about who has to provide it. It talks about who has to maintain it. What that means is wash. Who has to clean it? Okay? General rules, generally the same in all the wage orders, is that if you require a uniform as the employer, you have to provide it, which means buy it. You have to maintain it, which means clean it. And then you look at who replaces it if something happens to it. And that's where you get into that conflict between the labor code and the wage orders, depending on, and the different wage orders have a little bit different provisions in there. What isn't in there in all of them, but applies to all of them, is this whole maintain thing. If I have an employee that I say, you have to wear our restaurant t-shirt, here's 5 of them, I'm making them wear it, so I'm required to provide it. I can't charge them for it. I give it to them. I have to maintain it, which I've told you means clean, wash. How does that work? Anyone have any idea with that particular example? Anybody? Bueller? Okay. If they can wash it with their normal clothing, then nothing. You don't have to do anything. If the t-shirt's a black t-shirt and they can throw it in with their jeans, then the employer doesn't have to do anything. If it requires separate washing, for example, it's dirtier than the clothes, you have to pay them 1 hour, and I can't quote this exactly, it's either 1 hour at their regular rate or 1 hour at minimum wage. I think it's minimum wage. 1 hour at minimum wage to spend the time washing their clothes separately. Nobody does that, and I've seen it in class actions, and it's an easy one. No one does it, so just be aware of that. Most people can wash it with their normal clothes. So what I would do is, if you're in that category, because it's not in the wage orders, I would put something in writing that says, here are your uniforms, you're required to wash them. If for some reason you can't be washed with your normal wash, let us know. Because if they don't, I'm going to assume they're washing it in their washing machine with their clothes. Anything that requires dry cleaning or special laundering, or where they have to go to a laundromat because they don't want to put the greasy stuff in their own laundry, you have to pay actual cost. So if you have something that says all clothing must be pressed and cleaned and whatnot, and they have to send that out, you got to pay the actual cost, whatever it is. Yes, Sylvia? Good question. And wage order 16, where it generally applies, is different than all the other ones. The question was, does the FRC fire retardant clothing or special safety, does it fall under uniform or safety equipment? It generally is considered safety equipment. Anything required by OSHA is going to be safety, not a uniform, and the employer's on the hook for the whole thing, for everything about it. They got to clean it, they got to do everything. There are some exceptions to that, very limited, of course, which aren't in the wage orders, but that's where it arises from. Clothes that people can use in the industry that they'll need for every single job. heavy boots. I mean, someone can't show up at a construction site in flip-flops and say, whoa, if I can't wear these, that's a uniform, you need to buy me some shoes, or you need to buy me some jeans, I don't have any. You don't have to do that. If you're a restaurant and you go with the black pants and the white shirt, you don't have to buy the uniform, you don't have to maintain it. Scrubs of a generic color, green, black, white, probably don't have to. If you say everyone's going to wear mauve with, a fringe on it, then it becomes a uniform. You've got to pay for it, okay? None of that's in the wage orders, but that's where it comes from. Yeah, I mean, I don't want to say it's not there. It is there, it just isn't that detailed. Don't take it at face value. You really want to learn that. Meal and rest periods, the whole brinker, all that came from the wage orders and also comes from the labor code. You're going to want to look at that. Pretty much everything's consistent now. There are some little differences between them. Changing rooms and resting facilities. Some of the wage orders have specific requirements for changing rooms. They'll say no bathroom. It's got to be a room. Like I said, the one with the overnight specifies what type of place that they have to have for resting. Seats. This was a hot topic about 2 years ago. This was the new big class action. Everyone was suing Walmart and banks and everyone because they didn't provide seats. It kind of went away to some degree. There was a court case that said, a California court case said, oh, come on, in this particular industry, it's just not practical to have a seat. It's like a car hop or something. I can't remember. They said they're not going to sit down during their job. They're on their skates or whatever it was. I can't remember. If you have employees who are in a position and they ask for a chair, I'd have a red flag. They say, I am entitled to a chair. Give them a chair. Unless it's one where you just can't do it. That's someone who knows this rule. We still see those claims. More often than not, it's just easier to give them a chair. Addresses elevators. I've never had to deal with that. Okay, so let's go through number 4. The exemptions provided by the DLSE. I just want you to look at that first section on the exemptions, and the point I want you to recognize, and if you haven't picked up on it already, is the section that says exemptions, section 1, are not the only exemptions in the particular wage orders. Those are what we call the big 3 exemptions. The other ones aren't necessarily labeled as exemptions. They'll say, does not apply. It won't say they're exempt. Sometimes it does. But you're reading through this body and all of a sudden it'll say, well, this section doesn't apply to blah, 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 blah. And then you look back at the definitions and you meet that definition. That is also an exemption. But if someone comes to you and says, I don't see that exemption, and they're only looking at section 1, it doesn't mean it's not there. It just means it's called something differently. Okay? Some of them have specific reporting and inspections criteria, documents that you have to have available for inspection by OSHA in some industries. There's a section on offsets for minimum wages for people who live on site. Okay, I see a lot of times where we'll see a wage claim where someone got, $500 every 2 weeks plus a free house, to be a caretaker or something. The problem with that is that if you look at their hours worked and you compare it to the cash compensation, if that puts them below minimum wage, you're only allowed a credit for a certain amount per your particular wage order for housing. It'll say something like $232 per month for one person for a 1-bedroom house or 1 bedroom, or for 2 people it's twice that or something. That's the amount that you can add to the total compensation to determine if you've met minimum wage. And that's all scaled. It has nothing to do with the value of the house, the value of the room, the condition, the size. It's just a set number. If someone is living on site, like these storage places, do the math. You can credit yourself with $167.14 per week or per month or whatever it is for one person living in a one bedroom. All the rest doesn't count. It's just compensation that you've given them, okay? All of the penalty, not all of the penalty, lots of the penalty provisions are in the wage orders. So if you're going to make a business decision to do or not do something based on operations, something required, I would want to know how much does it cost. If it's $10, I'll probably do whatever I want to do. If it's a bigger number, you got a tougher decision. It talks about penalties per pay period and these liquidated damages. So you go to that section, you figure out, here's what we need to do. Well, we don't want to do that. Okay, if we don't, here's how the penalties are going to be defined. But don't just look at that. You then also have to look at the labor code, because the labor code has its own penalties generally for all the same stuff too. So if you add those together, then you can make a business decision. And then finally, the posting requirements, generally the same for most of the orders. The biggest mistakes I see are, A, they're not posted, which in the past wasn't that big a deal, but now if you get any sort of a visit, they really fine you for that. 2, you don't have either the updated one or the correct one. It's from a long time ago and it's just not valid anymore. The third most common is that you don't have all of the right ones. You order the package from the chamber, they stick it on the wall, you think you're good, and it turns out you've got 3 different wage orders. Okay? I have seen those in claims when there's a site visit. So if the DLSE gets a wage complaint and for some reason they want to come do a site inspection, that's the first thing they look for is that poster. And that just, once again, it's just penalties. And then finally, the fourth one is that it's just not accessible to anybody. Where are the posters? They're in the general manager's office. Where? In the closet. Okay, well, no one can see those. You got to be in somewhere normal traffic areas, okay? Here's the detail on the industry orders for you to refer to. It just covers what I talked about, the hybrid, the occupational, and the industry. Let's put some examples in there. Some of the overlap sections with the labor code, the final wages, when you have to pay them, the failure to pay wages, the payday, the timing requirements, when you have to pay commissions, those are addressed in both. The posting of the regular paydays, you have to let people know. And they're a little bit different, but they're in both places. And then the biggie is the wage statement obligations. Right now, the labor code is a little more detailed than the wage orders, than most of them. So if you comply with the labor code pay stub requirements, for the most part, you're going to comply with the wage orders, but you're going to want to make sure on your specific wage order. And that's a big class action right now, too. They're looking at it. If something's missing, they're suing people. Some of the resources, the first one is, what wage order? There are some resources on the IWC website, and I've put those links in there. There's some cheat sheets to kind of figure out maybe what industry you're in. You can download, under the second bullet, you can actually download the actual wage orders. That's where we got this one. I just went to the site and printed out number 4. And then that final one is just the overall DLSE website. And the important part of that, going back to sort of the hierarchy of what you have to follow, labor code, statute, wage orders, regulations that have gone through the Administrative Procedures Act. Below that, you have enforcement policies and opinion letters of the Labor Commissioner. All of that is on the website. So if you go to an opinion letter and it addresses something in particular, you might see your question right there. Do I have to pay someone who does X, Y, Z? You pull it up. You read the opinion letter. Or you look at the Labor Commissioner enforcement policy and it says, yes, you have to do X, Y, Z. If it doesn't cite to a case in there, an italicized someone v. somebody, it's probably an opinion or an enforcement policy, not necessarily the law. If it cites to a case, what that means is that it wasn't in the statute, wasn't exactly in the wage orders, there was a lawsuit and a court decided something on it, okay? That then has the force of law. The only other disclaimer is that the labor commissioner in their enforcement manual is not always honest about what the court said, okay? So you see a court case and you go, oh, we have to do that. Not necessarily. They misinterpret and they misstate those sometimes. I'll give you an example. In the professional exemption, non-licensed engineers and whatnot, the California enforcement policy is that for non-licensed, you can have this learned professional who's had a course of study and whatnot, and it says, consistent with federal regulations to meet this, and it cites the CFR section, the person has to have no less than a master's degree. So you've got this person who's doing engineering work, they don't have a master's degree. California says, based on federal law, this particular section, they can't use this exemption from overtime. When you go look up that section, it doesn't say that at all. It doesn't even mention master's degree. It says an advanced course of study. That's it. So they do misstate stuff a little bit. And the reason I'm pointing out specific examples is if someone comes to you and says, I was on the internet and I looked at XYZ and this is the rule, and it was on the DLSE website, that's where I found it. You still want to go through the analysis, have us go through the analysis. Labor code, wage order, let's look at the opinion. Is it based on a case, and was it accurately enforced by the labor commissioner? Okay? There's a lot of gray when you get into the weeds. Any questions? Anything specifically about the wage orders that I did not cover that you wanted desperately to know? Great, quiet today, thank you. That's all we got.